The defining feature of the agency relationship is that the agent can actually bind the principal to the third party. That is, it creates a legal relationship between two people who may never have met, the principal and the third party, which obviously has significant implications. So the question becomes, is there any limit to the kinds of obligations that can arise, level of contract between these two parties? And to understand the answer to that question, we've got to turn to a critical component of agency law, and that is the scope of authority. Let's get into it. Imagine that you walk into a coffee shop and rather than ordering a coffee, you decide that you would like to buy the coffee shop. I don't know, maybe you've come into a lot of money, you love coffee so much, and you love this coffee shop so much. So you go up to the barista and you say, hey, this looks like a great coffee shop. I'd like to buy it. How much? And the barista goes, I'll sell it to you for $1,000. You go, done deal. Shake hands, have a contract. Or do you? Or more specifically, do you have a contract with the principal or the owner of the business? To understand the answer to that question, we have to look at where the authority of the agent actually comes from, their scope of authority. So just to recap, the principal, in my little example, the coffee shop owner, authorises the agent, the barista, to act for them, and the barista has to report back and be accountable back to the principal. And then the transaction for the coffee shop occurs between the barista and you. Okay, you've come in, you're having this transaction, and what it does is it results in a contract between the coffee shop owner, which could be a business or it could be an individual, and you, the customer. So if you bought a cup of coffee, for instance, the contract for the sale of the coffee is between you and the coffee shop, not you and the barista. That's what the agency relationship is talking about. Now, very importantly, you can see here the principal authorises the agent. The coffee shop owner says to the barista, you can do certain things. You can, for instance, sell coffee, you can make coffee, you might be able to order supplies. So when most people think about this scope of authority, that's what they're thinking about. And in fact, what they're really thinking about is express actual authority. But the tricky part of this area is that there's lots of other kinds of authority. These kinds are no less important than this one. If an agent has any of these sources of authority, they have authority, whether or not the principal expressly told them. And therefore, they will be able to bind the third party and the principal in contract, irrespective of how they got that authority. So the only way you can tell whether the agent has authority is to go through each one of these 5 areas. Now, for the purposes of this module, we're not actually going to worry about agency by necessity. That occurs, for instance, if there's a natural disaster and the normal rules are out the window. So let's not worry about that, but we are going to deal with these other 4 areas of authority, these 4 sources of authority in the agency relationship. The first of these, express authority, should be fairly easy to understand because we've run across this idea before when we heard about express terms in contracts. You might remember that express terms are those that were written down or spoken. They're expressed. And it's the same here. Express actual authority is what the principal either writes down or tells the agent they're allowed to do. Now, that written form can be lots of different things in the business world. For instance, it could be in your position description, it could be in your letter of appointment, it could be in a delegations manual, it could be in an email. There's lots of ways to express it in writing and verbally. If you're going to do it properly, you should set out things like the duration that it's going to apply to, the scope or limits to the authority, what they're allowed to do and not allowed to do, and any remuneration and entitlements that come from it. That's just good contracting, right? So a good express authority will set those things out. And we've got our case here as an authority for that because we're back into common law. They're cases for this particular week's module. We're looking at Freeman and Lockyer and Brockhurst as our authority. Okay, express authority. That's the one we naturally think about. Okay, the next one is reasonably intuitive, but it's not about express authority, it's implied authority. So what are we talking about with implied authority? Really, when you think about it, you can't see into the future. So you don't know exactly what your agent's going to have to do. And sometimes you can't write down every single thing that you want them to be allowed to do. It'd be too tedious. And from an economics perspective, they'd say the transaction costs of doing that are too high. So instead, we write down the main things that you want an agent to do. We would express those. And the agent would also have implied authority to do things that are incidental to carrying out the main tasks that you've given. For instance, say you're running an online business and you employ someone to sell the goods through your online business, but you don't say anything about shipping, right? It would be implied that the agent could go to the post office and send it and that you'd have to pay for that shipping. It's incidental to the task. You can't sell things online without shipping it if it's a physical product. That task is incidental to the main task. If I employed you as a chauffeur to drive me around in the car, but I didn't mention you being able to buy petrol, well, it would be implied you have the authority to buy petrol if you're going to drive me around. How else could you drive me around if the car has no petrol in it? Now, importantly, just remember what's happening here. It means that if you go and fill up at the petrol station, the contract for the sale, who's responsible for that bill, is me, not the chauffeur. That's what the agency relationship does. And even though there was nothing in writing in the job description about them filling up with petrol, it would be implied. They would have implied authority. It's necessary for them to be able to do that to carry out the main task of driving me around. So implied authority generally arises in one of three situations. The main one that we deal with is if the task that they're doing is incidental to the main task. It's necessary to do the main thing that they have express authority for, filling up the petrol to drive the car around. Or it could be something that normally goes with a job. Like you could also argue chauffeurs can normally wash the car, right? So therefore, if they had to buy some car washing materials like a sponge and some, that would be something that you would expect a chauffeur to be able to do, because chauffeurs normally keep the cars clean, so therefore that would be implied authority. Implied authority goes with tasks that a role can normally do. And finally, some industries or businesses have their own customary practices, they're called, so their ways of doing things. And so if normally someone in that role, I don't know, maybe it's in agriculture, and if you happen to be herding cattle, I don't know, you might be allowed to do certain things normally that most people might not think about, but if you're in that industry, you know that they can normally do it. That would be an implied authority as well. Now, bear in mind, what we're not saying is that implied authority can overrule express authority. I'm not saying that. So if you employed me as a chauffeur and you wrote, I'm not allowed to buy petrol, I can't use implied authority to say I can buy petrol. So just be aware of that. Implied authority is where it's silent. There's nothing expressly giving me authority. But if you expressly deny me, then you can't imply it. Okay, so just be super clear about that. The principal can at any time direct what the agent can and can't do, of course, as you would imagine. The principal can control how much authority that they give the agent. Implied authority arises where it's unclear due to silence. And they're sometimes referred to as two types of actual authority because the principal actually gives them express authority and the implied authority is based off that actual authority. It's incidental to the authority that they're being given. So we call those actual authority, actual express authority and actual implied authority. But the next one is where we get really tricky. So the trickiest area in scope of authority is this one called apparent authority. And to fully understand what's going on in apparent authority, I think it's really important to have a look at one of the cases, which we don't often do because we're not becoming lawyers, but I think this helps explain it. And we're going to look at the case of Summers and Solomon. So Summers and Solomon involves a jewelry store where there was a guy who owned a jewelry store and he decides to employ his nephew as an agent to manage the jewelry store. Now, after a period of time, he realises that the nephew is dodgy and hopeless and he shouldn't be in charge of the jewellery store. So unfortunately, for their familial relations, the uncle sacks the nephew. But that's not the end of our story. That's the start of our story. Because what the nephew actually does is after they've been sacked, so after they're fired, the nephew orders a whole lot of jewellery from a third-party supplier. Now, of course, when the nephew does that, he says he's ordering it for the jewellery store. And because the nephew's ordered from them before, they think nothing's wrong, so they supply the jewellery. And what do you guess happens? Of course, the nephew runs away, or in legal terms, not in legal terms, in criminal terms, goes on the lam, because he's stolen the jewellery. The nephew steals the jewellery and runs away. So no one can find him. Now, in an ideal situation, how we solve this problem is we get the jewellery back and we give it back to the supplier. But we can't do that because the nephew has taken off with it and is probably out of the country, and we're never going to get that money back. So now the problem for the court is whose jewellery was stolen. Did the nephew steal the jewellery supplier's jewellery? Or did the nephew steal the uncle's jewellery? That depends upon whether there was a contract, right? If this order was a contract, then the uncle owns it. If this wasn't a contract, then the nephew stole the jewellery supplier's jewels, not the uncle's. So what's actually happening is the supplier, the third party, is arguing that there's a contract between them and the uncle, the principal, and so therefore, when it was ordered, this contract was in place and the nephew stole their jewels, and therefore the uncle should still have to pay them, even though the nephew took the jewels. The uncle, of course, is arguing, well, I sacked my nephew. He had no authority to order, so there's no contract because there was no authority. And what did the courts do? Well, the courts looked to this area of apparent authority. So this is a bad situation because really, again, I just want to reiterate, we should be getting the money back from the nephew, but we can't. So who should lose? The uncle or the supplier? And I think what the courts are really saying is, really here, the uncle employed someone dodgy. So if anyone's going to have to bear the loss, it should be the person who took the risk, who employed the dodgy person rather than the supplier. And there are a number of commercial issues that arise if we don't have these rules that I'll go through. So as a result, the law has come up with a rule where authority arises when it's apparent or when it looks like someone has authority, whether or not they expressly do. So quite clearly here, the nephew does not have express authority because they've been sacked. But let's look at the rules for apparent authority. We've got to ask these questions. Did the third party know that the agent didn't have authority? So put it to you this way. If the jewellery supplier knew the nephew had been sacked, they've got no case. But the jewellery store didn't. They didn't know that the nephew had been sacked, so it met that rule. The second step, the second element, the principal held out the agent as having authority to act. So the principal must do something to make the third party think the agent has authority. What did the uncle do? The uncle employed the nephew as a manager. The uncle had let the nephew order before. The uncle, the principal, had done something to make the jewellery store think the nephew could order. Okay, that is. And finally, it must be reasonable for the third party to rely on that holding out on that action. So what we've got to ask is it reasonable for a jewellery supplier to believe that a manager of a jewellery store can order jewellery, particularly when they've done it in the past? I think that's entirely reasonable. That's just commercial reality. And so that is met. So because those three elements had been met, the nephew actually had authority. Even though he was sacked, the nephew had apparent authority. Now, I know that could seem a bit crazy because he's been sacked, okay? Yes, it's a different kind of authority. Think about it this way. When you walk into any store, you walk into a clothing store to buy a t-shirt, and imagine if this rule wasn't in place. You wouldn't know whether the shop assistant could sell you a shirt or not. Maybe for some reason the principal doesn't allow that person to sell the shirts. So that means for every transaction with an agent, you have to ask, do you have authority? Can you give me evidence that you have authority to sell me this shirt? Like that's just commercially unreasonable. And so what this rule is doing is getting around that situation. It's trying to handle situations, for instance, when you walk into a store, you should be able to expect that the shop assistant can sell you something as an agent. Okay, these are normal commercial relationships. When there's a manager of a jewelry store, they can order jewelry from someone else. And it puts the responsibility back on to the person appointing the agent. The principal has to make sure that they're controlling their agent appropriately and not entering crazy contracts. So, for instance, in the situation of Summers and Solomon, what the uncle should have done is written to all the suppliers saying, hey, I've sacked my nephew, don't deal with him, he's a dodgy bugger. If he had have done that, then the jewelry supplier wouldn't have sent the jewelry over to be stolen. And even if they had have, rule number 1 wouldn't have meant it because they've been told the nephew didn't have authority. So really what it's saying is if you appoint an agent, you've got to take responsibility and monitor what they're doing. And that's why we have this rule of apparent authority, the trickiest one that we actually deal with. Remember, you've just got to run the 3 elements, run the test. The key is that the principal has to do something. They've got to hold the agent out as having authority. They've got to do something to make the third party think that the agent has authority. Okay, we've done express authority, we've done implied authority, we've done apparent authority, and the final one we're going to do is authority by ratification. It's a simple concept. It's where the agent didn't have authority, but later the principal says, hey, I like that deal, and endorses it. They ratify it. And the effect of that is that the agent actually had authority when they did the deal. So it's not a difficult concept to understand. I think people get this idea that you can endorse or ratify something, so it says the deal's good. The difficult conceptual issue that you need to be aware of is that ratification acts like a time machine. The agent had authority back when they made the deal, not when the principal endorses the decision. Let's just give you a quick example. So imagine there's this principal who says to an agent, hey, can you buy me a car, spend up to $20,000 on a car? And the agent goes out looking to buy a car, and there's a third party for some reason who's selling, I don't know, a Porsche for $22,000. Maybe it's one of these situations you hear about legendary disputes like divorces where one of the partners will sell the other party's goods for a very, very low price out of spite. So maybe we got that kind of situation going on. They're selling a $200,000 car for $22,000. The agent sees that and goes, dude, that's a fantastic deal. And they sign the contract. Okay, at time 1, they sign the contract. Did the agent actually have authority? Well, they didn't have, right? They could only buy up to $20,000. I'm not going to worry about apparent authority, etc. at this stage. So we're going to say the agent doesn't have authority at time 1. Now, at time 2, the third party gets back with their partner and says, well, I don't want to sell a car anymore. I want the car back. And so what are they going to argue? They're going to argue that there's no contract with the principal because the agent didn't have authority. Okay, so if that's true, if there's no contract here, then they will still own the car. And let's just say independently, a day after the third party has come to this decision that they want the car back and they've found this out, so they're going to go and say, yes, I want the car back. I know you don't have authority, so I'm taking the car back. And just say on day 3, the principal talks to the agent. Maybe they've been away on a trip and they come back and the agent says, hey, I bought this car for 22. I know I was a bit over, but I hope you're great. And the principal goes, that's fantastic. I endorse that deal. Okay, so at time 3, the principal endorses it. So the question is, can the third party, who has now said they don't want to be part of the contract, get out of the deal? And the answer is no. Because this ratification here at time 3 means that the agent actually had authority at time 1. The authority doesn't start here, the authority starts here when there's a ratification. And that's the tricky bit about ratification. Not the endorsement, that's pretty clear, but when it takes effect. It takes effect back when the agent kind of didn't have authority at that point in time, but they do have it at that point in time because there's a time machine taking it back. Hopefully you get the idea. Okay. So just to reiterate, key area of agency law is, does the agent have authority for the deal? If they don't, there can be no contract between the principal and the third party. If they do, then there is a contract, then obligations and entitlements between the principal and the third party arise. And the only way you can know whether the agent has authority is to go through all of those elements: express, implied, apparent, and by ratification. And super importantly, you can't just look at what the principal actually said to the agent. That's only one source of authority, express. You also really have to look at apparent and implied as well, because the agent may have authority even if the principal said to the agent, you're not allowed to do it, which can mess with your mind a bit. Okay, that's why it can be a difficult area. Anyway, super important area, scope of authority: express, implied, apparent, and by ratification for the purposes of our module. And in the next video, we're going to move on to start looking at the duties that the agent owes back to the principal as a result of this power that they've been given.